Hello, thank you for joining us today. This is Claudia Johnson, and with me I have a really exciting panel of presenters. And today we're going to be focusing on the ABA guidelines that happened in August. Before we get started, I just wanted to let everybody know that the call will be recorded, and we will share the recording via the list, Twitter, and other emails and other means of communication, so people can review it and have access to the slides, etc. And we also put in the chat, just to call your attention to the chat, and a folder that's available with additional materials and some of the documentation on the regulation. And we'll put the recording in that folder too, so everybody can access that. So without more, I am going to turn it over to Marc Lauritsen, who's our moderator. And we're going to start with Richard Granat, who's going to give us the history of these guidelines, which have been long in the making. So Marc, I'm gonna make you presenter.
Okay, guys. Hey, this is Marc Lauritsen. Good afternoon. I'm here with a bunch of other folks. We've got an action-packed agenda today. Let me just kick it off and ask Richard to set us up a bit. We're dealing with the American Bar Association's best practice guidelines for online legal document providers. This happened in August. We've got several other folks joining us today. I'm not sure if it's Scott Kelly or Thomas from Community Lawyer who's with us, one or the other, or both. Dorna from Documate, Matt Newsted from Illinois Legal Aid Online, Jessica Frank from Cali, plus Claudia, of course, and Miranda from Pro Bono Net. And I'm not sure, Claudia, about Rohan Papin-Lori from Uppsala, but possibly we'll hear from him or her. And potentially others and those on the call. So we have a lot to do, but Richard, maybe I'll let you give some history and context for these guidelines, and I've just got a screen to help guide some commentary here.
Okay, that's great. Let me mention a couple of high points. So the genesis of these guidelines was the New York State Bar Association, who originally moved to kind of get the ABA to pass a model regulation, which would eventually be adopted by the states. In fact, there were some draconian aspects of that proposed statute. It was almost really anti-competitive, and there was lots of pushback from other ABA sections. And there was a whole process that went on all last year, which ended up deleting the most heavy-handed aspects of this regulation and evolved into what we call a best practice guideline, which is voluntary and not binding on the states. But I think that we'll see some states pick up aspects of it in the fullness of time. The impetus originally was frankly from solos and small firms in New York State that were feeling the competitive pressure from non-lawyer legal document providers. But the rationale, of course, is consumer protection, and to try and come up with a set of best practices which are favorable to consumers. And I just want to mention a couple of things which I think are relevant to this community. Generally, if the community decides, I think it would be a good thing to try and comply with the guidelines, because they have been sanitized to the point where most of them are really pretty consumer friendly. And I think I had added comments to the guidelines that I think Claudia circulated. I want to mention a couple of things about the guidelines, just so you be aware. Certainly, the guidelines apply to nonprofits as well as profit-making entities. And if you go through them, most of them are pretty straightforward. I don't think you'd have one would have a real problem with them. So, but one thing you might note that in Guideline 3, we had a big war over the original statement, which said that vendors must waive the as-is warranty. That's a real problem for software vendors. I don't know of any software vendor that offers this product without an as-is warranty. And if you're a private company, if you don't have that as-is warranty, it's impossible for you to raise any kind of venture capital. So the bottom line on this was providers may limit their warranties to as-is warranties using notifications consistent with best practices guideline 2, which means that you can continue to offer your services as an as-is warranty. Now, whether you're profit making or nonprofit, my recommendation is always to have an as-is warranty, because without that, you really open yourself up to liability. The second thing that's kind of significant to point out is this idea that users must affirmatively accept their terms and conditions statement, which means that the terms and conditions statement must come up in the screen and there must be an affirmative click-through. Now, many commercial companies, including ones that I've run, have always had that in place to begin with. And the idea is that the user must be more aware of what's in the terms and conditions statement, which should be clearly written. Many of the other guidelines that are in place here, I don't really have a problem with. Like providers should notify customers how long they intend to keep their customer information, or providers should notify their customers that their forms are not a substitute for the services of a lawyer. Anybody in this business should have that kind of disclaimer on their website already. There was a movement on the dispute resolution clause. So if customers had a problem, they could resolve it not by arbitration, but at least in a forum which is convenient to the customer. Again, I don't really have a problem with that. There were more serious constraints that were eliminated as it went through this process. And to give you a flavor for that, something like 8 to 9 sections of the ABA ganged up against the New York State Bar to try and sanitize these guidelines so it wouldn't be a chill on innovation and to make them acceptable. And that group was actually led by Perlman, who is Dean of Suffolk Law School, who I know Marc knows well. And the result is something that, I could actually live with. And it's something I think for the legal services community to consider, because I think it would be a plus to get the community to kind of support it. There was another point that lawyers, there should be links to lawyers, the availability of lawyers on legal document provider sites. And again, I don't really have a problem with that. In fact, our standing committee on the delivery of legal services had a resolution passed about 2 years ago through the ABA to recommend that there be links to lawyer resources like Community Lawyer on legal document sites for people who feel they need legal advice. So from something which was going to be very difficult to live with, I find the guidelines manageable. Now, we don't know how these will evolve when states take a look at it. The latest scheme to come out is from Florida, which is a little bit more difficult for legal document providers to comply with, except that it doesn't apply to nonprofits, so it's not relevant to this community. I think I used up my time, right?
Not fully, Richard, but thank you. I've just been scrolling. Sorry, folks, for sort of passing things quickly, but just scrolling through the 15 pieces of these set of guidelines. And as Richard said, some of them are quite moderate. Some I think are still pretty controversial. I, for instance, just find it offensive that the ABA would tell non-lawyers that they have to notify their customers that their forms are not a substitute for lawyers. It just seems monopolistic.
Yeah, I agree with that.
What we wanted to do in this first phase was just to give you folks a sense. I'm gonna jump back to the top to say, again, the scope, as Richard said, these are designed to apply quite widely to for-profit and nonprofit. So those people on this call, the LHI and the Community Lawyer and A2J Author and related communities, are all in this together. We're kind of targeted by these guidelines. and forms that are designed to be used by lawyers or by clients of lawyers or by courts are not within the scope of this. So that just sets the context a bit. I think Claudia and others have thoughts on each of these 15, or some, at least many of these 15 topics, and we wanted to take a little time to dig into some of the challenges and opportunities they present for us. One thing I'd like to just say is that it is pretty clear that some of these apply mostly to the content provider and some of the platform provider, right? So some of our services involve an overall arching layer of a publisher like LawHelp Interactive, which has certain responsibilities and obligations and opportunities to interact with the user. But then we turn the baton over to the content provider, you know, a legal aid program in Arkansas, and their particular interview and form. And then the content is really their responsibility. So it's really this joint responsibility between the provider and the content provider with some overlaps. Let me give Claudia a quick chance to jump in. Claudia, I think you had some.
So in point one, right, that's about plain language.
Yeah.
I put on the chat that the LHI terms of use are approved by LSC every time we change them. Those are approved by an advisory group. So, you know, we think about them very carefully, and we've been a model in doing them in plain language. And in August of 2018, we did a recording for the legal aid community on how to implement the call. So I put that in the chat if people want to see that recording. In point two, I just wanted to point out that our approach in LHI is to have a click and accept for those that are not registered, because we do believe in anonymous use. We don't want everybody to register to use our forms. So those that are not registered get a click and accept before they start an interview. And we encourage owners to use plain language and budget for plain language in their projects, not just for the interview, but for the instructions, etc. In point three, which is a thing about distribution, I think in the LHI world, this is done by distribution, meaning that the websites are local. You know, you're not gonna find New York forms in a California webpage. And we encourage the owners not only to use the design of their website to limit jurisdiction, but also even the pull downs. And even some states, and Matthew hopefully will share a little bit more, some states do a little bit of a jurisdictional factual checkup before they let the person proceed to continue to the interview to assembly. In point four, which is the point about updating forms promptly, this is a little tricky one, because you know, how are form providers going to let the consumers know that the form may be when it was updated? So in November, we're gonna have our listening call with the community, and we're gonna talk a little bit more about how we think we're gonna do this. So I invite all of you to come and give us feedback. But we think that form owners should also be putting in their forms, and some of them are. Like if you look at Washington LawHelp, they put on their website when the forms were last updated. I think that it should not just be on LHI, but on the owners, not on just on the platform. Point five doesn't apply to LHI because we're not doing filing for people. Point six, I believe most owners are already doing this in LHI. We encourage people to do this, and some people have a disclaimer that says, do you understand that this is not advice and whatever, click yes to accept, and then they move to the interview. I know New York courts do that. I don't know if other states do, but it's something that we do encourage. Point seven is the terms of conditions. Like I said, they're reviewed. We don't just make them up and change them as we want. And we're very specific. And then if it's a form that's going to be e-filed, or if it's a form where we may have enhanced reporting, in the interview itself, we also have a click and accept, and we even require people to put in their name and last name to signify consent that we're going away from the regular LHI policy, which is we're not going to sell your data, we're not gonna share it, just to get exact permission to e-file a particular form with a court or to do some enhanced reporting on behalf of that owner. In terms of, I'm gonna skip to show the one on Washington. You know, point 10 is data retention policies. Everybody should have that. We run them by account type. We've had them for many years, and we actually do check on ourselves to make sure that the deletions are happening as we tell the public. We have routine checks on that. So we're pretty serious about not keeping data. For us, less is more. So I encourage everybody to think about data retention policies by the different account types. We don't charge fees on LHI. People, point 11, you know, I don't know what excessive fees mean, but in LHI you can come and create your form over and over. And then point 12, in LHI we encourage people to put this in the website wherever people find the interview. And an example of this is Washington LawHelp. In the divorce with no kids, they have a talk with a lawyer paragraph that they have there, and we encourage other people to do similar things if they're creating self-represented forms. If you're creating pro bono lawyer or legal aid lawyer, you don't need to worry about any of that. And I think that I'm going to stop here in the interest of time, but in the slides that I post, I have comments for all of the points from LHI. But my main message to everyone in the LHI community is to join us in November, because we're going to be sharing what we think we're gonna do to make like the notification, the who owns the interview, when was last updated, and how to contact that group. We're gonna have a discussion with the community to see where in the system that could be, and if we need to do anything else, because we already letting owners put that in the title of their interview. We encourage people to put that on the website that they use to distribute the interview, etc. But you know, there's always room for improvement. So for those of you in LHI, join us so that we can prioritize some of this for next year. And I think we give it to Jessica, right?
Yeah, before we do, let me just ask Richard to give us a quick update on what he knows about other jurisdictions. So we have the national ABA stuff we just looked at. Many on this call know about California, but there have been similar things happening in Florida, Tennessee, Washington. Richard, can you quick summarize?
Yeah, so California's recommended, a little controversial, that digital legal service providers will be in a safe harbor if they register with the state, which is kind of unusual. Now, Florida has, the bar has actually approved a registration scheme that applies to commercial entities, not nonprofits. It's a voluntary scheme. So if you volunteer and conform to a set of requirements, then you can use a Florida bar seal of approval on your site. It's up before the Florida Supreme Court for approval. There were some issues there about whether the Supreme Court will actually approve that regulatory scheme. I know that Marc and I have discussed the fact that we think that all these schemes have prior restraints under the First Amendment. Tennessee has been tabled for a year. Washington State, I think, is also just in the comment stage. Utah just passed a scheme to create a safe harbor for non-lawyer digital legal service providers, again, provided they conform to certain requirements. That's pretty much all I know about what's going on. Oh, Arizona is also.
That's right.
Yeah, Arizona is passing a safe harbor concept. So I think Marc's article is worth reading, Safe Harbors and Blue Oceans, about this idea about a safe harbor and what it really means.
Thanks for that.
It's actually threatening, I think. Chill on innovation, my own view.
On Washington State, I just wanted to update the group that got, and it's not moving forward. The Access to Justice Commission recommended against it. And the technology group, including Sarro, me, and others in the technology community, provided testimony in May. And I'm going to put in the box the recording of a call where we debriefed on how that played out in Washington State if others are interested. But the key in Washington was to get the Access to Justice Commission involved. because these proposals are not surgical. They're not targeting one thing. They're throwing everything on the kitchen sink. And you know, in public policy, one of the things you learn is that you are very surgical, you're very careful, and regulation is not generally the first thing that a policy analyst will think about when trying to improve an area. There are other tools of public policy, and regulation should be the third or fourth when everything else has failed. So we talk a little bit about that in the call and how that played out in Washington if people want to listen to it.
Cool. Thank you, Claudia. Let's give some other folks a chance to jump in here. No, Jessica, I think you have something to show and say, so I've made you presenter if you choose to accept it. And you're on.
Awesome. Can everyone see my Google Doc?
We see and hear you.
Yes, yes.
Okay, great. So I'm Jessica Frank. I'm A2J Author's project manager, and I went sort of the practical approach here and trying to give you live examples that I thought fit into these new guidelines as a way to model it. And Matt Newsted is on the call, so he might recognize some of these because I think Illinois does a really great job in terms of their instructions and the sort of I'm not your lawyer putting on that hat. But I did pull these from several different state examples. So hopefully you can see the screenshots, but they're sort of, I just did a random sampling and found a bunch of really good ones. So for clear instructions, it's always good to let the people know up front what they're going to be completing, what the actual document is, what they're going to need to complete it, and any instructions or anything extra that they would need to fill out the form. How long it's going to take, I think that's particularly helpful. When you finish, you can download your forms, that you're going to need to file them yourself. It's always good to have instructions at the end about what happens next. I've seen great examples, like in the New York courts, they print out an instruction sheet that comes with the user's downloaded forms. And so it gives them the form itself and then also sort of a cheat sheet of what to do next and how many copies to make and that sort of stuff. In terms of notifications, this is explaining exactly what interview it is, that it can be used in criminal, not civil, that certain fees can be waived. So that's just notifying the end user what exactly they're completing. Another tip that we push for A2J Author is to get all of the qualification questions out of the way. So that's in the beginning. And that sort of fits with the third point in the guidelines about making sure that people are using it in the correct jurisdiction and what to do if they're not in the correct jurisdiction. And so we really recommend that you lay it out up front exactly who is appropriate to use this form and then kick people or move them out of the interview as soon as possible if they're not appropriate. On the keeping forms up to date, A2J Author has a report that can be run. It's within every interview. You can run it as many times as you want, and you can print it out if you want, or you can check it to see when it was last updated. You can also, under the About tab within an interview, you can mark what the current version is. You can put revision notes in it. It helps authors keep track of when it was last kept up to date, and to let anyone who has to work on the interview sort of the status of where it is in terms of compliance with the law. And you can also add in a screen. I've seen it generally like on the first question where it says last updated, and whenever the author updates it, that is shown to the end user as well. So that's an option. Disclosure of fees for filing, like Claudia said, LHI is free, A2J is free. We're free to use for authors, and we have a non-commercial license right now. So anyone using A2J Author is barred by our license by charging end users. Anyway, our terms and conditions and our sharing data notifications are on our website. So it's a little disjointed from the end user, but authors can access those right there. The non-attorney client issue is one that's very common I've seen in pretty much every interview, that there's that I agree or yes, no, I understand that this does not provide legal advice. It does not take the advice of an attorney. There's even learn mores that have been included about how is this different than getting advice from an attorney. that explain it further to an end user. So I think we already have that covered. The disclosure policy, so there's some interviews that talk about the security of the site, how information is kept secure and confidential, and if you're on a public terminal, how to make sure to keep your information secure by closing out your internet browser tab when you leave. The point 10 about intent to retain data, A2J is not hosting yet any interviews, so that is on the host organization's sort of responsibility. No charging of excessive fees. Like I said, we're free and we have the non-commercial use license right now. Not a substitute for a lawyer. That's generally in that I agree, I understand. And the suggestion that it's not the same as a lawyer is sort of in that same, does not provide legal advice, does not take the place of an attorney. And this is sorry, it's so small, but this is learn more that includes the how is this program different than getting advice from an attorney. So let's see. Oh, and generally most of these, if the end user clicks no or I don't agree or does not click the I agree button, they're taken to a follow-up question that will not let them move on in the program until they agree to whatever the provision is. And most interviews have a send feedback button. Let me grab a screenshot that has this one right here. The send feedback button allows end users within the interview to send feedback both to the A2J author team, we get a copy of it, and to whatever email the author has set up. So there is an ability for end users to send feedback, and they use it all the time. So that's sort of real life examples of how you can implement these guidelines in A2J. That's my portion.
Hey, thanks, Jessica. Hey, Matt Newsted, do you want to add anything to that from the Illinois Legal Aid Online perspective?
Matt, you're muted.
You seem to be muted, so if you want to talk, you need to unmute. There we go.
Oh, sorry about that.
You're on.
Okay, yeah, I can go ahead and talk now, or did you want to have me come in a little bit later? Either way, it's fine to me.
I think since you're talking now, let's go with you. You're not going to show anything, just talk, right?
No, I just had one slide with my contact information.
But I'll make you presenter so we can see that while you talk.
Okay, sure, that'll be a little more exciting.
We need excitement. Anything we can get.
Let's see. Can you see it? Oh,
We're seeing a screen. We're seeing your untitled document. There we go.
Great. All right. Thanks.
Cool.
So my name is Matt Newsted. I work at Illinois Legal Aid Online, or ILEO. I just wanted to say thank you for talking about this topic, and I'm encouraged by the community's response to it. As was already been brought up, ILEO we create automated document programs, and we host them on, or LHI, LawHelp Interactive, hosts them for us. So our programs exist in a layered environment, and as we've already been talking about, the different groups are responsible for these different pieces. So we really need to coordinate how we're going to apply these guidelines to make sure we have full coverage. And I just wanted to highlight two areas where we're doing this. The first is instructions, and the second is the handling of data. First, with regard to instructions, the users of our automated document programs are moving between several websites and resources. They maybe get to our programs from ILEO's website, then they'll go to LHI, then they'll start an A2J Author or a Hot Docs interview, and then go back to LHI for the documents delivery. We're already, all of these partners in this process are already striving to use clear, plain language, but we need to coordinate our explanations and instructions in the interviews and how to use the forms so that we're keeping in sync, both so that we're providing a unified experience, it's not disjointed, but also when the different platforms make updates or changes, we need to be sure that we're keeping those aligned so there isn't any confusion brought up. The second area I just wanted to mention was the handling of user data. again, since there are many or a few players involved, different groups will be responsible for different things. So Aleo collects some user data based on the website usage, and we address some of it, or we express how we are using that data in our own terms of use, but that's on our and privacy policy that's on our website. But LHI, LawHelp Interactive, they receive the personal information that users input into the interviews, and that goes into the form. And that's already covered. Claudia brought up how that's done on LHI, but it just brings up that we need to work in concert, so we are transparent about how this can be handled, so that people are aware of what's going where and how it's going to be used and stored and so on. The last thing I wanted to mention that I think we might need to talk about is, or we, Aleo, need to consider, is an affirmative acceptance of the terms of use. So on our website, we have that, like many websites, it's kind of a passive acceptance, that they'll see that by using your website, you're agreeing to these terms. But then once they start the interview on LHI, they are prompted with the affirmative acceptance. And I'm not sure whether we need to do more. We, Aleo, and other content providers need to do more to make sure that that affirmative acceptance provides full coverage back to the content creator. So those were the things I wanted to mention.
Hey, thank you, Matt. We may come back to some of this and some questioning at the end if we have time. But let me give Dorna the floor if she's able to take it. And Dorna, do you want to show anything or talk, or neither or both?
Yeah, so can you guys hear me? I actually kind of just wanted to share a little bit about what we're doing at Documate, and it's kind of fairly similar to what the rest of you guys have already talked about, going through the points and of the regulation. So first of all, and I don't have any slides to show, but we are planning on doing some more educational materials for our users, which others are welcome to join in on as we schedule those for earlier next year. But as a baseline, we already have an active terms and conditions consent form that both registered users and non-registered users all must click through and accept. By default, these are Documate's terms and conditions, but our clients, who are the workflow creators, or as we're calling them now, the app or template creators, they are able to add additional terms to those conditions based on how they're using data before they share their own apps or templates with their clients or the public or members of the public. So that would all be implemented into the system before the click and accept functions are placed on the public site. Second, we are by default placing an introductory page on every single workflow that is shared with the public with the last edit date. So that's automatically set to the initiation date unless it's actively edited by the app or template creator. It's also going to include provisions for the fact that there's no attorney-client privilege. And because we feel like these types of workflows are best managed in conjunction with live attorneys, they also need to have the information, name, address, email of the lawyer or whoever has set up the workflow, as well as our email address in case someone wants to reach out to us for any kind of complaints in conjunction with the regulation. And those are sort of just kind of the basic. As a platform, we are making those available to make it as easy as possible for our users to comply. So that's what we're doing, and I can let you guys know as we initiate some of those webinars that we're planning on doing specifically on our platform and going through the visuals as well.
Cool. Thank you, Donna. It's an exciting part of this call this is one of the first calls we've had a variety of the different sort of competing, collaborating platforms all be together because we face common issues, right? So we have Documate, and we have Community Lawyer, who I'm going to call on next, and the A2J world. We overlap, but we also sort of compete with each other, and that's healthy. Is Thomas here, or is it Scott who's going to be here from Community Lawyer?
I'm here. You have Toma. Scott couldn't make it, unfortunately.
Okay, Toma, you got the floor. Do you want to have this? Do you want to present or just talk?
Just talk. Just talk. Thanks for having me. It's fun to be here. I don't have much new to add. We're in a very similar position to the rest of you all, where we look at these guidelines as something to share with our users. A little bit of background, our users on Community Lawyers would be the providers in these guidelines. They're the individuals who make the workflows, make the quote, document assembly apps, end quote. So considering that 90% of these guidelines are around what these providers should be notifying to their clients, I love the idea that Dorna brought up. I love the collaboration that's happening on this call. If we could all come together and create a list of best practices of our own, our own interpretation of these guidelines and what they practically mean as you go and author your document assembly apps. What counts as a really effective disclaimer? What are some good examples of people doing it right? What are some examples of people doing it wrong? That's the role we see to play. There's a lot of small features we've considered adding to the platform as a result of these guidelines. This idea of allowing the provider to indicate when their app was last updated. We thought about doing something like Google Docs, where every time you update your app, this little byline might get updated at the bottom of it, updated October 22nd. But maybe we want to allow someone to just review it without making any new changes. And that review should be accounted for. So maybe it's just a date they can set. Oh, I reviewed this yesterday, though I didn't change it. It's up to date as of yesterday. But that's it from us. Just love the idea of creating a set of guidelines we might share with our users, but otherwise I have nothing new to add.
Cool, thank you very much. Let's see if any of the other panelists, did I miss anybody, or does anyone want to add something to something they've already said or react to each other? Richard, you kicked us off. You've been in this business longer than any of us, I think. Any kind of parting words before we turn it over to the audience more generally?
I'm thinking that we're going to go through a period, if the states begin to take hold of this, that we're going to have more regulatory activity at the state level. Connecting A2J commissions with bar association regulatory committees is probably a good thing. Yeah. I think that's an important dimension. The problem in this area is that some of these proposed regulations may have borderline constitutional issues of free speech. We know, I don't know if I sent this to Claudia, but Department of Justice and DOJ over the period of years has sent letters to bar associations to try and get them to back off on regulating non-lawyer enterprise on anti-competitive grounds. And we have the dental examiner's case, which is another constraint on this. Some of that analysis I sent to Claudia previously. So I just think we're going through a period of uncertainty, and we don't know how it's going to work out yet in the fullness of time. One impact could be a chill on innovation of private companies. The nonprofit community may be more insulated, but even then there's a problem. You can't pass regulation that discriminates between nonprofit and profit-making companies. And also, these developments really go beyond just automated documents. As we move into the area of automated legal advice and legal bots and other kinds of digital tools, the same issues really come into play, where essentially we have a digital application substituting for the labor of a lawyer. I mean, that's what we're really talking about. So one can see how this concept of a digital application substituting for labor of a lawyer has legal profession-wide ramifications. It's certainly happening in big law firms with new contract analysis tools and smart e-discovery. But that's a different context because it's happening within the law firm. In our context, what we're talking about are direct-to-consumer services, which are not mediated by the attorney-client relationship. So it's the most disruptive development, I think, in the legal profession. And we've been waiting for this for a long time. I thought this was going to happen 10 years ago, but now it seems like everything's accelerating as the technology becomes more and more powerful. And it's not just automated legal documents. We're going to have automated legal advice bots and other kinds of tools which will help people who can't afford lawyers make their way through the legal system. It's kind of ironic to me that this regulation that the bar has passed somehow affect the 80% of the population that can't afford lawyers in the first place. So there's a kind of disconnect. There's a disconnect going on here, which suggests that the intentions of the bar are not fully honorable in terms of what people actually need.
And Richard, can I also comment that I think the Access to Justice Commissions need to be part of this discussion?
Yeah, I agree.
Because in a lot of states they're not in the committees. And the other thing is that you don't have public interest lawyers in these committees either, who may understand what it could mean to require confidentiality requirements on a tech platform, and how that could end up disallowing service. You know, a computer will only remember what you program it to remember. So how would you, what would the impact of a confidentiality requirements on a tech platform be when you're serving opposing parties, right? It's not going to remember unless you have to then run a six-way conflict to deny people services. So I think Washington State could be a model on how an Access to Justice Commission intervenes, or how a tech committee, if your state doesn't have a tech committee in the Access to Justice community, a commission, you should work to create one if you're in this call, because it just doesn't impact these things, but also like, providers that want to charge people, litigants, every time they print their own file and things like that, and all kinds of proposals get approved whenever courts get into document assembly. So really encourage anyone that's sitting on an Access to Justice Commission to look at this. The other thing is from a national perspective, a lot of these rules are really destructive in the sense that, are you really going to register and have a service agent in 50 states? And what grant, at least for nonprofits, what grant is going to cover administrative costs like that? Those are really local registration requirements, and then supporting a community that of 1,800 user organizations that are creating and sponsoring these forums so that their users can use them for free. How do you do that? These things, every state is just looking around their belly button, but they need to consider the impact, that will have. Do you really only want to have a platform that only works for your state? And will that platform be robust enough and have enough revenue to really do the expensive security work that something like this requires, right? Or to really spend hundreds of thousands of dollars on a server that a robust service requires. So there's a lot of consequences here with this fragmentation that's really starting to happen. And really people should think, is regulation the way to go? Are there other approaches that go to incentives and internalizing the externalities that could cause a lot more good than these things? And the other thing, in Washington State, there was no evidence of harm. There was not one complaint. But they were trying to criminalize anyone that referred anyone to a document assembly practice if they didn't meet the requirements. Criminal penalties. So like, what would the librarians gonna do? We've worked really hard to bring other communities to feel comfortable referring to these tools, those that don't have lawyers. So what is the impact gonna be on the network? These groups are not thinking about these things and all the hard work that has been done since the internet was invented. So there's a lot of repercussions at stake. So I think invite your Access to Justice committees to put their hats on and get involved. I want to open it up to the community, but just as a resource, and I put it on the chat. In response to Thomas's question, I think we should continue, and maybe we can talk about having a joint call 6 months from now so people can report where they are and what they have found helpful or not. But New York did this grant many years ago. You can look, it was funded by LSC, and there's this plain language library that has a lot of actually examples on how to do disclaimers across areas of law, etc. So don't reinvent the wheel. This was done by Trascend, which is one of the best plain language companies in the US, in my estimation. So feel free to use this, and I put this in the chat, but feel free to go here and look, because if the language is already there and that applies to your state, you think it will cover your state requirements and definitions, feel free to use it, because that's what it was created. We had a question about GDPR, and the question was whether the ABA guidelines included the GDPR. My response was that the ABA guidelines preceded the GDPR, but I wanted to make sure either you or Marc, Richard, you or Marc can comment on these don't include that, right?
No, they don't include it, but there's
Okay.
an overlap because some of the GDPR requirements kind of surface in the ABA guidelines, like affirmative click-through of the terms and conditions statement and the use of data. So there's an overlap, but they didn't really consider that in the discussion. But they do reflect some of the requirements of GDPR. Yes.
I just want to emphasize Claudia's point, I think, and Richard's also, that the folks in the trenches of doing this good work, creating legal apps of various kinds, unfortunately can't avoid paying attention to the regulatory environment because it's evolving and potentially threatening, can impose costs and obstacles to our important work. So it's not just the commissions, but it's those of us who are creating apps and our sponsors and clients that need to be actively monitoring what's going on and part of the conversation. So we have another 10 minutes or so, I think. We have room for commentary by fellow panelists. Any questions people want to make? Probably given the number of folks who are listening to us, it should be by typing them into the question pane. I'll just be quiet, and Claudia or others feel free to speak up to add some thoughts, and we'll see if anybody wants to raise any comments or questions from the audience.
Yeah, if you want to comment, raise your hand and we'll unmute you. Don't be shy.
All makes sense? All totally clear?
Okay. So let's go to quickly just to LHI updates, which are for the community as we wrap up. But raise your hand if you want to ask a question or make a comment or share something. Maybe you already have something really good that you want to share. The one announcement that I wanted to make sure everybody knows is we're going to be doing the live training in Portland 2 days before ITC. So the registration is open and it's first come, first served. So please sign up if you're interested in joining us. The other thing is we're going to be doing tomorrow, we've been doing work with New York CLJV and funded through the Office of Victims of Crime, really looking at technology to prevent elder abuse and fraud. So on the 24th, we're going to cover the last part of a webinar series that started with the project and then sharing how programs can adapt a risk detector that was created for elderly. And on the 24th, we're going to talk about 3 types of forms that we're creating that will be available for use for national use that go to preventing elder fraud. And I wanted to flag that it's DV month, and I did a run on LHI, and we have done 41,000 domestic violence related documents till October 11th, and that included weapons, orders, initial complaints, and financial issues per the NIMSI codes. So just congratulations to all of the partners that are using LHI to help victims of violence. Some other conferences coming up, and I put here the SRLN recording on what happened in Washington, the Washington debrief, if others want to watch it. But let me stop and see if anybody has any last minute questions or comments.
We had
Or
a question from John Grecian about why the courts were accepted. Maybe Richard knows. Why did the ABA put the courts out of the scope of these expectations?
I just think that that was an environment that they thought the courts would handle directly. With basically the courts offer standardized forms, and that's just a good question, but
It's just politics.
yeah, I think it was politics. I mean, the idea was that the courts would take care of their own and do what's right by the court. But I could see some of these rules or practices applied to courts as well. I mean, there's no reason why they shouldn't, put it that way.
Right. Yeah, we have some court folks on this call, right, who were doing this in serious quantity.
Yeah, I can imagine.
Mm-hmm. John Mayer also had a comment or question. I'm gonna unmute you, John.
You're gonna kill me. So, I mean, every time this comes up, I always ask the question: How do we know that the paper forms are up to date, or when they've been last updated? And doesn't it seem a little unfair? I don't know. I don't think it's unfair, I guess, but it does seem a little unfair that we have to conform to rules that the current paper-based system doesn't.
Mm-hmm.
And I'll leave that as a let anybody respond to it.
Well, these rules apply to everybody. It's all document vendors in this case, whether it's pay to play or nonprofit.
Just online though, Richard, right? I mean, they're only addressing the online digital market.
Oh yeah, that's correct. It's only online digital
world that John Mayer is referring to.
It doesn't apply to books though, right? Like how to avoid probate.
Yeah, right. Yeah, I get all that too. Yeah, I think that was a dangerous area for them to go into. We have case law which says that they're publications and protected from these kind of rules and regulations. You can see what kind of a thicket this is, because the same analysis in theory should apply to online as well as books and publications, right? We have a line of case law that suggests that would be the case. The reality is no of these lawyers have done any really deep research on the application of the First Amendment in this whole area. I mean, it's like bad legal work, frankly. I don't think we've heard the end of this. This will continue to unfold.
Maybe the end of the beginning here. We should probably give Claudia a chance to give the last word here and wrap us up. But Claudia, back to you.
Okay. No, I really thank our partners in the same space and that joined the call and shared their insight and approach. I do welcome feedback. You will get a survey, and if you want us to do an update 6 months from that and come back and share what we've done individually or maybe even collectively, we can set up a call for 2020 to continue the conversation. I think that Richard and Marc are on point. This is not going to go away. There's regulation mania happening, and hopefully some people will bring real policy analysis, which lawyers are not. Lawyers argue rules, interpret rules. They don't craft policy well. So hopefully, some people will bring real policy analysts to look at things other than regulation. Guidelines like this, voluntary guidelines, voluntary or even mandatory standards could be a second level. But really want to thank the audience too. And I'm going to be sharing this via the list where I publish and on Twitter, including the folder that's going to be a Dropbox that's going to have all of the materials. And I'm going to add the links that I shared in the call. But our next call is on the 19th of November. And it's going to be the community feedback session. So if you have requests for LHI, bring them and be ready to share them. And we will have some ideas and proposals back to you to hear what you as a community want to do or would prioritize considering limited resources. And then in December, we're going to have our national webinar on building collections that work through a case that's moving forward and not just stopping at initial pleading, and what technical things and standards have to happen with variables and fields, etc. So that should be a really fun one, more advanced LHI work. So thank you, Dorna, and thank you, Thomas and Richard and Mark and everybody that participated and helped me out with this call. And I hope we can do it again maybe later on.
Thank you.
Terrific. Thank you.
Thank you.
Thanks,
Okay.
bye.
Thank you.
Bye-bye.